We'll now hear from counsel in the second case, City of Gainesville versus CEM Enterprises.
Good morning, Your Honors. May it please the Court, I'm Steve Brannick of Holland & Knight here representing the City of Gainesville. If I may, I'd like to reserve 5 minutes of my time for rebuttal. In this contract construction dispute, the trial judge granted a new trial on damages alone, correctly observing that CEM had not proven the damages that was suffered as a result of the alleged breach of contract. We're here this morning because we think that the trial judge didn't go far enough. First, we think that the trial judge should have granted summary judgment to the City of Gainesville because the contract clearly puts the responsibility for the control of excess water flows on the contractor, CEM. But secondly, at the very least, we think the trial court should have granted a new trial on both liability and damages. Let me start, if I may, with the water flow issue. There is absolutely nothing ambiguous about this contract here. Paragraph 1.10 of the contract says that the contractor shall control the creek during construction. Paragraph 1D says that the contractor is responsible for the design and implementation of methods to keep a dry stream bed. Paragraph 2.4, the contractor must control at a minimum 30 cubic feet per second, or CFS, as we say in the brief. And most importantly, in paragraph 2.4, the contractor must protect its work in place, and if the flow exceeds all of the damages of the contractor's responsibility. There's no ambiguity about that.
But counsel, I agree that reading those contract provisions on their face doesn't appear to raise an ambiguity. But as I understand it, the issue of an ambiguity arises concerning what this addendum number 1, which is on its face says it takes precedent over anything to the contrary, and that there are, as I understand it, references in that addendum that are in conflict with sort of the minimum flow expectations that are provided in the contract. Could you address that, please? Because we're confused.
Yeah, I think if there had been evidence in this case that the contractor was in fact confused by the discrepancy between the addendum and the main language that I've been talking about that requires 30 CFS, I think they'd have a good point. But Mr. Meeks, the president of CEM, was asked specifically, you knew you had to control 30 CFS, right? And his answer was yes. There was no confusion, and it wasn't until after the contract that they jumped on, after this dispute developed, that they jumped on this discrepancy between the 30 CFS in the main document and the 1 CFS in the addendum. Remember, they're relying very heavily on those 3 reports that we discuss in great detail in their brief. All those 3 reports talk about the water flow averaging 30 CFS or less. And in fact, that JEA report, the Jones-Edmonds report, suggested 99% of the time the flow was less than 20 CFS. So the discrepancy between the first part of the contract and the last part of the contract was not the basis of the case below, and we think is a red herring. Now,
what about I may be interrupting your train of thought here, but the argument that the city breached its contract by failing to provide material information relating to the contract, couldn't that have been the basis for a material breach here, even if the contract is unambiguous?
If there was information in those reports that indicated that the city's bid documents were misleading, the answer to that question would be yes. There's 2 problems with their argument. First problem is they've got the wrong legal standard. They're basically arguing to the court that if the city has relevant information and it doesn't disclose relevant information, then that can be the basis of a material breach. That's not what the cases say. I would commend to the court the 2 most important cases, the Jacksonville Port Authority case and the Hendry, which is out of this district, and the Hendry case out of the 3rd district, both of which say it's not enough to withhold relevant information. That doesn't create the breach. What creates a breach is withholding, is having bid documentation that's in fact misleading or misrepresentative. The Jacksonville Port case is a really good example of that. In that case, the Port Authority did some sample borings in the channel that was going to be dredged, and those borings showed that there was, and the boring information that they provided to the other side, the city represented to the other side. Those borings were representative of the channel bottom all the way through. Well, it turns out that they were not representative, and the city knew that they were not representative. There were actually some rocky hills and valleys in the dredge channel that were not shown by those dredging reports, and there's no way the other side could have known that, so that the bid documentation was misleading. Here, all the bid documentation says is that the flow is 30 CFS. That's exactly accurate. If you look at the Jones-Edmonds report, the
Council, wasn't there evidence in the form of testimony on the record that flows reached up to 360, between 360 and 390 CFS at some point in time?
Right. And their argument is, well, when it rains, the creek rises, and we didn't know that. Well, the most important thing, first, is the bid documents don't make any representations as to the maximum flow. All they say is that the average flow is 30 CFS. Now, the information and remember, this bidding process, the pre-bidding process, is a two-way street. They have the right to ask questions. Did they ever ask a question about the maximum flow? No, they didn't. And the information in those reports that they now say is so important comes right out of the St. Johns River Water Management District records, which are public records. If they really were concerned about what the maximum flow levels were before they signed this contract, all they had to do was go to the SJR WMD website. They could have pulled that information. It's all a public record. They never did that. The bottom line is they went into this contract without asking those questions, without doing that research, and that responsibility falls on them. The only way they have a cause of action against the city of Gainesville for breach is if they show that there's something in the bid documentation is affirmatively misleading, and there's no information in the bid documentation that's affirmatively misleading. So our argument's pretty simple. The contract puts the burden on them. There's nothing misleading in the bid documentation. Therefore, the trial judge should have granted summary judgment as a matter of law. On the second issue, focusing on the damages, again, we think the trial judge was absolutely correct to grant a new trial on damages because, as the trial judge recognized, they didn't prove the connection between the alleged breach and the damages that they suffered. Now, here's the situation in a nutshell. This contract is just under 40% complete when they walk off the job. They're not asking for 40% of the contract price. That's basically about what Gainesville paid them. What they want is $1.3 million on a contract that was $1.1 million. So they want more than 100% of the contract cost for a project they were only 40% complete. Now, the case law says you can do that. You can recover those extra costs that go above and beyond what you actually bid for. But to do that, you've got to show two things. Number one, you've got to show that there's a breach. And then number two, and most importantly for the purposes of this case, you have to show a connection between the breach and the damages that you suffer. So to put it simply in this case, you can't just load up all of your costs relating to the project and say, here, jury, give us everything that we put into this project. You've got to do more than that. You've got to come forward with evidence that connects the breach to the damages. For example, you could say, as a result of your breach, city, we had to hire 5 more employees, and here's how much those 5 more employees cost. Or, city, as a result of your breach, we had to buy this piece of equipment or that piece of equipment, and here's how much that equipment cost. That's the sort of information that you have to show. Or, for example, as a result of your breach, we incurred additional design charges. Here's how much those design charges cost. As a result of your breach, we incurred additional overtime. Here's how much that overtime cost. They didn't do that. In fact, their damage expert, Mr. Martin, was specifically asked, did you make any effort to connect up the cost to the increased damage, to the increased water flow? And he said, no, we didn't make any attempt to do that. And the fact is they couldn't have done that because they didn't keep those sort of records. Their cost records were very general, very incomplete. They made no effort to show what was happening on the project at any particular time, what their labor force was doing at any particular time. So they, in fact, couldn't connect up their damages to the breach. Now, there is a way that they could still prove damages, and I think this is an important concept, and it runs throughout this case, which is they could have relied on the total cost method. Under the total cost method, if you're in a situation where you're looking for these extra costs, like they're looking for these extra costs, you can put in all your information about what it costs to finish the project and recover that information if you satisfy a 4-part test. And that 4-part test says, number one, you have to show that it's impossible for us to make a connection between the breach and the damages because of the circumstances of the case. Number two, you have to show that your initial bid was reasonable. You didn't underbid the project. Thirdly, you have to show that your costs are reasonable. And fourth, you have to show that none of the extra costs were your fault. Well, they've disclaimed any reliance on the total cost theory, so they didn't try to prove that four-part test. Instead, they just put in all of their costs and asked the jury to award them anything without making that connection. The trial court recognized that and correctly granted the new trial on damages. And as we've said in the brief, we think that that new trial should extend to both liability and damages, because the case law is pretty clear that you don't grant a new trial on damages if the issue of liability is hotly contested. You look at this record, and it's clear that liability was hotly contested here. And secondly, the Brooks case tells us that you don't grant a new trial on damages alone if damages are interrelated with liability. And here, that's the essence of this case. You have to show the connection between the breach, whatever the alleged breach is, and the damages. And without that connection...
I guess I don't understand the interconnection. I understand because it seems to me the issue of breach is one thing. You can have a breach established, but CEM fails to connect the breach to the damages, and therefore the damages fail. And it seems to me that that argument goes to your motion for directed verdict on damages.
That's true, but it seems to me that the same jury has got to decide the breach and the damages, because the question is, what is the breach in this case? They argued lots of things were a breach. They argued the failure to disclose the information in the 3 reports. They argued that the supervisor on the project was a bit of a jerk and caused them to incur extra costs. We don't know what the jury decided in fact was the breach. How's the second jury going to be able to connect the alleged damages to the breach when they don't know what the breach is? We think the same jury has to decide both breach and damage. That's short of it. I'd like to reserve the rest of my time.
Counsel, just one question before you sit down. After the city terminated the contract with the appellee, the city contracted with another contractor to finish the project. Is that correct?
That's correct.
Okay. Were this contractor allowed to do things any way differently than the appellee while on the project?
There were, in a few minor respects, the contractor was allowed to do things differently.
And what were they?
I can't, truthfully, I can't remember off the top of my head, and I didn't put that in my oral argument notes for this morning, so I can't tell you exactly what it is. I suspect that counsel will inform you on that. But the bottom line is that the second contractor had no trouble completing the project, even though that second contractor encountered some very large rain events. It was the rainiest December on record when this contractor was finishing the project.
During those rain events, was this contractor required to stop the flow of the creek?
Pardon me?
During those rain events, was this contractor, the appellee, required to stop the flow of the creek?
The CEM, yes, the contractor was required to at least protect its work. Now, what EBC did, the subsequent contractor did, was it protected its work, let the water go past, the rainwater went down, and then they came back in and finished the project. So they worked around the rain events, essentially.
All right, we'll reserve the balance of your time. Thank you.
Please, the court. I'm Mike Piscatelli. I represent CEM. Excuse me. I'd like to reserve 3 minutes for rebuttal on my cross appeal. Let me respond first to your question. The replacement contractor first did its work in the dry season, which is what Golder, the designer, had said should have happened, but didn't. The replacement contractor was given water flow reports with its contract, which we were not. And the replacement contractor was permitted to go on to the completed work with its equipment, which we were told we would not be permitted to do. And we believe there was also evidence that the supervision, the inspection of the replacement contractor was much more friendly than it was of CEM, and there was evidence to that effect at the trial. Your Honors, the only error that occurred below was the trial court inexplicably deciding after the fact that the damages presentation we had made was not enough, after vetting that presentation completely throughout the course of the project. This was the most scrutinized damages presentation you could ever see. I thought we had agreed by the time we got here today in the briefs of the measure of damages, because there is a string cite, a page-long string cite of cases that say the measure of damages partially performed construction contract is either quantum merit or lost profit plus the reasonable cost of labor and materials incurred in good faith in the course of partial performance of the contract. The city harped on proximate causation in their initial brief, but in their second brief, they said, well, the proximate cause element is the good faith. You have to show that you incurred those costs in good faith. And we agree with that. And that's exactly the instruction that went to the jury and that the jury made its determination on. There's a case from every district and the Supreme Court that say that that is the measure of damages for a partially performed construction contract.
But as I understand what the trial court said here in its order, is that CEM did not introduce evidence relating to the reasonable cost because it had not only costs relating solely to the project, it also included costs that had a, quote, useful life beyond the project.
Interesting, because it was never an issue at the trial, but what we had testimony from our accountant that this was, I shouldn't say it was never an issue, it was discussed in the context of repairs to the equipment. And we had testimony from our accountant that there are two ways you can capture those costs. You can charge it to the job that the equipment's on, or you can charge it to an overhead account and spread it over all of the jobs at the end of the year, and that either one of those is within the realm of generally accepting accounting practices. So there was testimony that supported that. There was no contrary testimony that said that was not an acceptable accounting practice. And frankly, that was an afterthought issue, if it was an issue at all during the course of the trial.
But if what I'm struggling with is if the trial court's correct in its sort of finding about the costs, why shouldn't the trial court have granted a directed verdict? Because if the trial court thought you hadn't proven up your cost.
I don't believe there was any question that we proved many costs. I mean, we bought materials, we installed CRM, we installed permanent sheet pile. There were many things that there was no question that we did. This was a very minor element of the $900,000 presentation. And that's why we were surprised to see that in the order. Not only was the evidence presented in accord with the proper standard on measure of damages, but it was completely examined before it went to the jury. It was the subject of most of the cross-examination by the city. Of the 4 people that were involved in the damage or in the cost system. But more than that, the city argued a directed verdict that some of these damages shouldn't go to the jury. And the trial judge said, that's fine. Give me a list of all of the damages you don't think should go to the jury. It was on a Friday. They came back on Monday with a notebook full of them, and they had all the invoices in their computer. I mean, they had them on PowerPoint. They gave him a notebook that had $40,000 worth of items that they thought shouldn't go to the jury. The trial judge took that notebook home, went through, and made a decision on every one of them, yes or no, and did not permit many of those items to go to the jury. We took that on our damages chart that our expert had prepared and affirmatively deducted them in red so the jury would know, don't consider this. The judge has decided you should not consider this. The items that went to the jury either were not objected to by the city or were affirmatively decided by the trial judge were appropriate for the jury to consider under the appropriate instruction which they got. And that's why we were shocked and we think it's inappropriate that the judge, after making all that effort and after doing that gatekeeping effort in an exemplary manner, then turned around and said, we think you should have a new trial on damages. I'm not sure what we would do differently.
But wasn't it clear that the jury here reached the damages by simply subtracting from the contract amount the amount the city had already paid CEM? I mean, isn't that the only way the math works?
It is a way the math works, and it's probably what they did. I mean, we don't know. There were thousands of permutations, but let's assume that's it. That serves to our detriment, and we're not objecting to it. You know, the contract amount shouldn't have been a cap on the amount of damages. We proved up $890,000 worth of what we believe were reasonable expenses. The jury had a right to make that decision. The odd part about that calculation, though, is that the city argued at pretrial that our damages should be limited to the contract value, the unpaid contract value. The judge said, yeah, that makes sense to me. And we argued, no, that's not what the limitation should be. Look at these cases. it is sort of a logical thing to think, and if that's what the jury did, that's to our detriment, not to anyone else's, but it's still, that verdict is within the realm of verdicts which are certainly reasonable and unassailable at the end of the day. And we proved up more than that. If they limited us, I'm sorry they limited us, but they did. I'd like to talk about the summary judgment issue for a moment, if I may, on ambiguity. First, I don't think they preserved that for appeal, and this is why. Oddly enough, this isn't as clear in Florida law as you would think it would be, but the judge denied summary judgment, but there were several arguments that were made against that, one of which was the Jacksonville Port Authority argument. You needed to give us the information. The other was it's ambiguous, and the other was commercial impracticability and impossibility. The judge simply denied their motion. He did not make a firm ruling of ambiguity in the contract. The issue never came up again. It was not raised at directed verdict. It was not raised at post-trial, but more importantly, they agreed to the jury instruction on ambiguity.
But counsel, in regards to the denial of the motion for summary judgment by the city, what was the question of material fact that was in dispute as a ground or basis for denying the city's motion for summary judgment? Was it the information that was provided to the appellee, or was it the contract was ambiguous?
If you look at the transcript, and it's the only way you can tell, both arguments were made. I made the argument. Both arguments were made.
Okay. Why was, getting back to the first argument regarding the information that was provided to you, was not allegedly provided to you during this process, why does that constitute a ground for denying the city's motion for summary judgment?
Because the motion was for final summary judgment as to liability, and that is a liability argument. Our response was twofold on that liability argument. First, there are ambiguities.
This relevant information that you were not provided with during the bidding process is a basis for denying the city's motion for summary judgment as to liability?
Yes.
And why?
Because under the clear language of Jacksonville Port Authority, I mean, we can do this lawyering up here, but Jacksonville Port Authority.
What question of fact did that create for denying the motion for summary judgment?
The question of fact was whether there was material information that they had in their possession and were required to give to the bidders. Jacksonville Port Authority, the trial court found that the defendant had a duty to make known to the bidders on the project its full knowledge of the possibility of rock in this area. This court said, we agree. And that the question of whether there has to be an affirmative misleading, I think, is possibly a question in the third DCA, but it's not something you have to decide.
Did you make that argument that you were misled?
Yes. Yes. I mean, you can draw that wonderful distinction and say, well, we told you that the normal flow is 1 CFS to 30 CFS, and we had this information in our pocket about what happens when it rains. And it's not just that the creek rises when it rains. I mean, what happens is the entire watershed of the city of Gainesville goes through that branch. It can rain somewhere up north and flood you in that branch. And they had that information, and any contractor would be misled if told, this trickle is what you have to control, and not told, but when it rains, you're going to get...
Was that what you were told? It seems to me the trickle representation may have been in addendum number 1,
yes,
but the average flow would indicate that it's much greater than the trickle indicated in addendum 1, is it not? And an average would say, well, that's the average, and here's a trickle. There must be some days when it's a lot more than the average.
And they had that information. I mean, sure, there's the average, well, let me back up. The addendum 1 would suggest that the average is 1 CFS. The contract says 30. We could have controlled either of those. But the information that they had and didn't give us is what happens in rain events. And it's not just knowing that the creek rises when it rains. I mean, they had 20 years of studies that showed exactly what happens when it rains because of the watershed and the areas out in all parts of town that flow through there. And it's misleading, even if we have to show misleading, it's misleading to say not give us that information. If you look at Jacksonville Port Authority, I believe, adopts the federal superior knowledge rule. If the owner has superior knowledge, they have to provide that. It's clear in the federal system. I believe Jacksonville Port Authority is based on that also, and the 3rd DCA thought that in Inman when they summarized what Jacksonville Port Authority meant. But one way or the other, in this instance, they had information that misled us because they didn't provide it to us. The case in Jacksonville was, well, there's dirt out there. They didn't say, well, there's dirt and there's rocks. Here they said, well, there's a trickle. They didn't say there's a trickle, and when it rains, you're going to get wiped out completely. And that Golder report, that design report they had critical information that should have been provided to the contractor, and the city's representative said so. The city's representative admitted that that should have been provided.
So is it your position also that this critical information that you referred to, it has also made the contract ambiguous?
No, I believe those are different arguments. I believe there's ambiguity inherent to the contract. That's a standalone reason for breach.
Now, educate me again. What is the ambiguity itself?
The ambiguities are, is the normal flow 1 CFS? Is it 30 CFS? Do you have to keep it completely dry? Do you have to completely divert the stream? All of those things are contained in the contract, or do you just have to control it? Todd Anderson, the Golder engineer of record, admitted that there were inconsistencies in those various portions of the contract. I want to take just 1 second to talk about new trial on damages versus new trial on all issues. There's nothing that's more segregated, damages and liability, than a partially completed construction contract. Once you show the breach, then you show the measure of damages. There is no intertwining. We had this exact case, my firm did, in the Levitt versus Smith & Company case, where the 4th DCA reversed because they didn't believe the damages had been properly presented, but reversed only as to damages and said liability was established. The cases that say hotly contested are cases where there's evidence of a compromise verdict, almost always in comparative negligence situations. No compromise here. No breach by CEM, breach by the city, 80% of our damages provided. There's no compromise verdict here. If you do think there needs to be a new trial, it certainly should only be on damages. Thank you.
Okay, we'll reserve the balance of your time, Mr. President.
Just a couple of quick points, Your Honor. First, if we had said it in the bid documents that the highest you're ever going to see is 30 CFS, then I'd agree with them. But that's not what we said. We said the average is 30 CFS. And that is exactly what the reports show. Then he says, well, the city had information in its pocket. It had superior knowledge. Not true. All of the information in these reports comes right out of the St. Johns River Water Management District. The knowledge is as readily available to them as it is to us. That's completely different from the Jacksonville case, where the knowledge was only within the city's hand. Very important distinction. Now, in that huge string site that they have about the proper measure of damages, there's a big difference between this case and those cases. If they were seeking 40% of their contract price for a 40% completion, then I'd say that's exactly right. The problem is that they're asking for a lot extra here. They're not asking for 40%.
Counsel,
they're asking for 120%.
Would it make a difference if this information was, let's say, we all agree is absolutely critical to the process, but was a public record? Would the city, in that case, be under an obligation to disclose this information to the bidders?
What the city's obligation is under the Jacksonville case and the Henry case is not to put misleading information in the bid documents. They haven't identified any information in the bid documents that's misleading. So if there's nothing misleading in there, then the fact that they may have additional relevant information, or there may be additional relevant information in the public record is not relevant. But as I said on the measure of damages, the big difference in this case is they're asking for extra damages. And this court, in its McDivitt case, which I commend the court to, in 1979, said very specifically, if you're looking for extra costs, not just your 40%, but 120%, you've got to show the connection between those extra costs and the breach. You can't just throw all of your damages against the wall and ask for everything. You've got to make that specific connection. That connection wasn't here, and that's why we think that the trial judge should be reversed for failing to grant summary judgment, and at the very least, we need a new trial and everything. Thank you very much.
All right, thank you.
Just very briefly, McDivitt is not a partially completed construction contract case. It's a total cost case. This is not a total cost situation. You've got to complete the project before you can think about doing total cost. The information in Jacksonville Port Authority, there's no reason it wasn't a public record also. That's not the point. All of these cases involve public entities. The point is that they had information that the contractor should have been given, and had the contractor been given that information, the uncontroverted testimony was he would have acted differently. He would have bid differently. He might not have bid. He would have planned his job differently. It was a breach for them not to provide that information. We proved damages under the proper measure of damages. Thank you.
Okay, thank you. Thank you both.